So I want to welcome everybody to our weekly webinar. My name is John Watts. I'm a consumer protection lawyer, and we do these at least theoretically every week. Now, sometimes court gets in the way, but I'm glad to be able to be with you guys, and I'm glad you were able to take time out to be here. And the topic I want to cover today is something that is really one of my favorite things as far as the law. And this involves when a debt collector or a debt buyer sues you and then you win. That can mean you get a verdict in your favor or a dismissal with prejudice. And then we find that debt buyer continuing to credit report even after you won your case. And I absolutely love these. We've been bringing these cases for probably almost 20 years now. And matter of fact, as soon as we get done with this webinar, I'm finishing up this 26-page lawsuit. It'll be a lawsuit against Equifax, Experian, TransUnion, Innovis, and then a furnisher or a debt buyer, debt collector. And now in this particular case, it happens to be an original creditor, but usually we're seeing these with the debt buyer. So companies like Midland, LVNV, Portfolio Recovery, Jefferson Capital, Calvary, those types of places. So very excited to share some stuff with you. Hopefully this will be of interest to you. Maybe you've been sued or you're being threatened with being sued, or maybe you've already won your case and you're wondering, what in the world do I do with my credit report? So this is something I think I filed a couple of these already this month. I've got this one that I'm filing today. I may file another one today if I have time, or it will start off on July 1st. And so we file a lot of these cases. And if you think about, and I'll get into the details here in just a second, but somebody has sued you and then you won your case. And so you don't owe the money. But yet this debt collector, debt buyer continues month after month after month after month to report to the credit bureaus that you owe whatever they say that you owe, when a judge has said you owe nothing. It's very, very insulting. And then you dispute that, and we're going to get into very much into the details, and I'll have a template dispute letter for you guys, a checklist for you guys about how do you dispute this? How do you get this off of your credit report? And then if they don't get it off, what about suing? And again, that's something that I enjoy very much. So let me just share my screen here, and we will get going with this. And okay, so this, as you can see, and I've kind of marked up some of these slides here, but what we're talking about is you've been sued, you've won your case. What do you do to get that off your credit report? And then what happens if they refuse to get it off of your credit report? So I think most of you guys know me. I have been out quite a bit. We had a case that it got changed at the last moment, but we were getting ready for a pretty significant jury trial. And so I've been a little bit buried with that, and about maybe 10 other trials that I've just sort of been able to resurface here for just a moment to do this, and then kind of get caught up over the holiday weekend. But for those of you who don't know me, I've defended people sued by debt buyers, companies, Midland, LVNV, Calvary, Portfolio, companies that don't exist anymore, that unless you've been in this business a long time, probably wouldn't mean anything to you. But those that I mentioned are ones that are currently filing thousands of lawsuits. And when I say thousands, I mean some of those just in Alabama where I practice, and then also have a lawyer, a really good friend of mine named Blaine Dixon in Tennessee, and he does the same thing there. We'll find some of these companies filing 1,000 a month just in one state. Now, obviously, if you live in California or New York or Florida, it can be even higher volume. So I'm very familiar with defending these lawsuits, and I'm very familiar with suing the credit bureaus when they don't fix this stuff after it's properly disputed. And then I train lawyers around the country in doing this. So let's give you a real quick overview of what we're going to talk about today. So again, you're sued by a debt buyer. You either win your case or And that can be a judgment for defendant or a dismissal with prejudice, same thing. And then you pull your credit reports to see, is that account on there? And you match it up specifically, not just we're guessing or we're saying, I got sued by Midland. I got a Midland account on my credit report. It must be the same. No, we have to specifically match it up in the most minute detail. And then we do a proper dispute. And then either they delete it or they don't delete it, and we sue them for money damages. So here's what we're not covering today. We're not covering how do you answer a lawsuit? How do you try one of these collection lawsuits? What happens if it's dismissed without prejudice? And we're not covering what about original creditors. So let's say you're sued by Capital One, Synchrony, Discover, American Express, Citibank, fill in the blank, and you settle with them. They sue you for $5,000, you pay them $3,000. What's your credit report supposed to look like? I'll tell you, there are a ton of errors with these original creditors. So we're not covering that today. If there's interest in that, just let me know, and I'm happy to do that next week. And so we'll dive in here in just a second. Let me just make sure on the comments here, and I'm going to try and keep I'll specifically reference the comments that sort of go along with what we're talking about. Then we'll have, assuming we have time, we'll have some Q&A at the end, and I'll try to go back. If I miss your comment, just let me know. Okay, so let's start with this. Your lawsuit's over, okay? So did you get the great outcome you were looking for? Could be a defense verdict, could be a dismissal with prejudice. You have to check your state, but every state I've ever checked says this about a dismissal with prejudice. That is what is called an adjudication on the merits. It means you've won. There's been an adjudication, a judgment. In other words, it's been decided and it's on the merits. Now, a dismissal without prejudice is of no particular benefit for us, okay? But with prejudice, at least every state I've ever looked at, that's considered the same as winning your case, okay? And so that's the first step. And then we want to pull our real credit reports, okay? And so I'm not talking about Credit Karma or, credit monitoring service. Those have some value, okay? Mainly to alert you, hey, is this account still on my report? But then you want to look at your real reports, and where I recommend you go is annualcreditreport.com. And you can go there once a week for free, at least through the end of this year, 2022. Probably that will be extended. So I guess it was almost a week ago, I shared a stage with a couple other lawyers and with John Olsheimer, who is sort of the go-to credit expert for the credit bureaus and the furnishers. And he and I were chatting about this while we were presenting about will the annual credit report, which used to be once every 12 months, will that continue to be extended for where you can get it once a week? That started during COVID. And I certainly believe it will. My memory is that John said he thought it would be as well. Now, it's up to the credit bureaus, who sort of run annualcreditreport.com. So we'll see, but at least right now you can do that. You want to save or print those reports to PDF. I can't tell you how many times people will email me. They'll say, here are my reports. And it's a link like transunion.com/your report. Well, that's not like, that won't take me to your actual report. You have to look for, and it varies, are you on your phone? Are you on a tablet, a laptop, desktop? What are you on? But you want to find somewhere in there, it will say like view report, print report, save report, and do that to PDF. And then you want to check that. So wherever you are, on your phone, a tablet, whatever, it'll save, then go click on that saved document, make sure it's actually your report, make sure it shows all the detail. Because once you exit out, like let's say you're pulling TransUnion first, you exit out to go to Equifax, well, you can't go back to TransUnion, you have to wait a week. So just be really careful, and this will be sort of a theme. We want to be very, very precise, double check everything here. So I point out here that, credit monitoring has some value, mainly just as an alert system. If you've got LVMV on your credit report and you won 4 months ago, and you're looking at your phone saying, hey, I have not received an alert from Credit Karma. You go back through your Credit Karma and there's no alert, and you see LVMV on there, so there's no alert that's been deleted and it's still on there, then that should be very motivating to say, well, let me go pull my real reports, Equifax, Experian, TransUnion. You can pull Innovis as well, not through annual credit report. You have to go directly to Innovis. And so that's the real value. Those actual reports, that's where the gold is, okay? Because anything else, the credit bureaus can say, well, that's not our report. We don't know where that data came from. But when you pull it directly from the bureaus, and you do that through annualcreditreport.com, then you're in good shape. All right, so let's see here. I got a comment here. This is a great lawyer, Ignacio from Puerto Rico. Said you're behind on your pending trip to Puerto Rico. Yes, I am. I am going to come see you. So I hope to chat soon also. So if any of you people are in Puerto Rico, I got a great lawyer for you there. All right, so let's look now at this slide. So it may seem like this is, we're going to spend too much time on this, but let me tell you a couple of stories. So we've got to match up the account. So we're sued on some type of account. And some of our lawsuits, they may have 3 different Midland or portfolio or LVMV accounts. But the point is, we're sued on something. And then we see on our credit report, hey, I got sued by Midland and Midland's on my credit report. So it must be the same account. I get lots of emails about that from my clients. And we're always telling them, check your credit reports. They go, well, it's on there. We say, well, let's see. Now, sometimes it's obvious. We're sued for $10,000. We won that case, and there's a $500 Midland account. Probably not the same account, okay? So what we want to do is just really explore that account and say, can we match that up with what's reporting on my credit report? So the dollar amount, is that the same? Doesn't prove it's the same account. Be a little bit of a weird coincidence to have 2 Midland accounts for $4,789, and that's the amount we were sued for. Okay, but we want to start there. Now, sometimes there's a little discrepancy. Maybe we're sued for $4,800, and what's on our credit report's $5,000. Well, now we want to look and say, well, is that the filing fee? Okay, and look through the history of that account, because we might see, and this was a Midland case we just filed against all the bureaus in Midland. I don't remember the dollar amount, but let's say it's $4,800. In June of 21, we were sued, and in June of 21, the balance goes up to $5,000. So, okay, that's weird, like kind of coincidence, huh? And then we looked up the filing fee, got the precise amount. It was exactly $200. And then we looked at the original creditor. Oh, this was Synchrony Bank. Okay, I was sued for Synchrony, and now Equifax won't tell you, but Experian, TransUnion will tell you who the original creditor is. Oh, that was Synchrony Bank. And so we start matching this up to say, okay, I'm starting to feel really confident this is the exact same account that I was sued on. And then we can also look at the open date. And let me say a word about this, because this can be confusing. The open date, we think for a credit card, well, that's literally when I opened up the credit card. Okay. For a debt collector or a debt buyer, the open date, and I'm not saying this is right, but what I'm saying is what happens. They list the open date as the date they received the account. Now, sometimes in the lawsuit, you look at the lawsuit, and attached to the complaint or the statement of claim or the civil summons or whatever your state calls it will be an affidavit from somebody at Midland or LVMV or whoever. And a lot of times they'll say in there, here's where we got the account. Here's the date we got it. Well, then match that up with what's on the credit report. And so if you were sued by Midland, there's a Midland account. It's the identical amount of money. It's the identical date opened or date when Midland got it. It's the same original creditor. Maybe when you filed your answer, they then started notating this as being disputed. In other words, we're finding all these data points that say this is the same account. Okay. Then we can feel certain. But it's really, really important to not skip over this step and not go, well, I just assume it is. Because I have seen where You might have you're sued for $4,000, and there's an account on there from the same debt buyer, and it's $4,005. We go, well, we assume it's the same, but it's completely different. So really, really stress, take the time and prove that this is the identical account. And then you're going to use that in your dispute letter to show the credit bureaus, hey, this in fact is the same account that I was sued over. All right, let's see. See a question here, Derek. Can we use a report from the bureau, not from annual credit report if they're hard to get, like TransUnion? Yeah. I mean, you could go directly to TransUnion or myequifax.com, Experian.com, and get the report there. I'll say this: it is more important to get the actual reports from the bureaus when we're talking about, we're just going through like charged off accounts, finding all the errors, because the credit monitoring stuff tends to be wildly inaccurate. But with this, it's unlikely, for example, Credit Karma would list Midland on there if it wasn't actually on there. But you do need the bureau reports to get into this sort of granular detail about the open date, the original creditor, and all these details here. Sometimes you'll get a payment history on one of the bureau reports that can be very helpful. Sometimes a running balance history. And so like if you get Equifax, now this is usually a printed Equifax, but a printed Equifax report that they mail to you, you'll see every month the balance. And usually when the lawsuit's filed, you'll see the balance jump up slightly if it changes at all. So very good question. Okay, so let's talk about the dispute process. So basically, you send a dispute, and we'll talk about how you do that, to the credit bureaus. They then go to the debt buyer, the furnisher. Why do we call them a furnisher? Because they furnish information to the credit bureaus. And so they go to the furnisher and they send a copy of your letter with all the attachments or however you do the dispute and say, hey guys, what do you think about this? Now, when they do that, both the credit bureau, Equifax, Experian, Innovis, TransUnion, and the furnisher like LVNV, Portfolio, Midland, Jefferson Capital, whoever it may be, they all have an obligation to do a proper dispute here. And then the only allowable response, in my opinion, and I say this, somebody that's been filing these types of lawsuits for longer than anybody I know, they have to delete the account. If they keep the account, then you need to look at suing them. And so, I have on here, and I'm not sure if my cursor is showing up on the screen or not, but where I have written only two options. That really is it in this situation. This is not something where you're saying, hey guys, you can correct this. You're missing some data or you have some contradictory information. I mean, if you won your case, at least every state that I've looked at where this has come up, that means you do not owe the debt. Well, if you don't owe the debt, how can Midland tell the world you owe $5,000 when you beat them in trial or they dismissed with prejudice? They can't. Okay. So two options. They can delete it and at least the credit bureaus won't get sued. Maybe you can sue the furnisher, the debt buyer. We'll talk about that. But if they keep it, then I would say what Midland or LVNV, Equifax, Experian, TransUnion, all those guys, what they're saying is they're saying, please, we're begging you, sue us. We want to pay you money. And of course, we'll delete this off your credit report, but we're begging you to pay you money. My thought is, why would we turn them down for that? Obviously, they want to be sued. They want to write out checks to us. And I'll say this about the credit bureaus. I've never had one of their checks bounce. Okay. Their money spends just fine. Same thing with these debt buyers who credit report. So if they want to get sued and pay you money, yeah, why would you not accommodate them? Okay. All right. So very fancy graphics here. You can see why I'm a lawyer and not an artist. Okay. But we've got, the little stick guy is you, the consumer. So you send a letter to the CRA, the credit bureaus, credit reporting agencies, and then they notify the debt buyer. And then the debt buyer is supposed to respond back to the credit bureau. And they both put all that together, and the credit bureau decides, are we keeping it? Are we deleting it? And then they notify you with the results. Well, if they delete it, fantastic, perfect. The process is working. If they keep it, that's terrible that they've kept it, that they're treating you with a lack of respect, that they're damaging you. And fortunately, there's a remedy. There's a solution to that. You sue them, and then they can pay you money damages that they want to settle. And of course, delete it. So let me tell you about the dispute process. Some people say, well, I love to do it online. That's okay. You can do it online. Just be very, very careful. My preferred way is by certified mail. And so why do we do it by certified mail? I have, people come to me and say, well, I want to save the money. Okay. I just want to put a stamp on it. I don't want to spend $7 or $10 or $14 or whatever it may be. And I get that. But here's the deal. When Equifax says, yeah, we never got it. Now if you had sent it to us, boy, we would have deleted that in like 24 hours, but we never got it. How are you going to prove they got it? Now, we have some things called the mailbox rule, and there are presumptions and evidentiary things that we can use at sort of a high level in a case. But why put yourself in that position? These are very valuable cases. Don't try to save a few bucks. Do the dispute the right way. Do it with certified mail. You can prove they received it, okay? And here's a great thing. So this case right now that I'm working on, there's a situation where one of the credit bureaus received it and then denied receiving it. And so they didn't do an investigation within 30 days, which is their requirement. Now they say they didn't get it. We've got certified mail saying they did. They blew their time. I got another one that received it and they did a results investigation about 60 or 90 days after receipt. They blew their time on that. Well, if we had just done it by regular mail, how could we prove? I mean, sometimes regular mail gets lost and then they deliver it. You just can't prove that. Or you're trusting the credit bureaus not to lie to you. Okay. Why would you put yourself in that position? Do it certified mail. Okay. Now, if you do it online, and I've harped on this, and very, very few people follow this advice, but I'm telling you, if you want to do the dispute online, you've got to record your screen. Okay. I don't mean taking screenshots. Okay. Because you could take a screenshot where, like, here's where I uploaded the document, in Equifax, who you sue later, they go, yeah, we see you did a screenshot, but evidently you deleted that attachment or that upload because we didn't get it. So how are you going to prove they got it? So record your screen. You can use Loom, Loom. You can just do Zoom. We all have Zoom basically, or some equivalent. Look, you start a Zoom session with yourself. You don't have to have, two people to do a Zoom session. Only one is required. You share your screen, which is the website that you're going to, Equifax.com, Experian.com, TransUnion.com, Innovis.com, to do the dispute. And I'd say that I think you can do an online dispute with Innovis. I've never actually done that. But you share your screen and you record it. Press the record button. And so all your movements are being tracked. Now, you don't need the camera on, okay? You don't need voice on. So you can turn off your camera, mute your microphone, but just to record it. And so you can, you click somewhere and say, I'm disputing this account. You type in something. Well, then when they go, well, that's not what you typed in. You're like, I got the video. Okay. I've got the video of me typing it in, pressing submit. Okay. I've got where I uploaded all these attachments, and we're going to talk about attachments in a moment, but I've uploaded all these attachments and I got the message, upload complete successfully. Okay. So you just want to protect yourself. If you don't trust the credit bureaus to do things correctly, and obviously you don't because they have an account that shouldn't be on there, why would you trust them to, we'll keep careful track of what you did with the online dispute? I can't tell you how many people get into depositions where they're being questioned under oath and say, well, now you didn't tell us about that you had won your court case. Oh, yeah, I did. We have no record of that. Where's your proof? Well, I just assume. Well, don't assume, okay? Do it by certified mail or record your screen, okay? I have something listed here, certified mail labels, and let me share my screen here. So this should pop up. So certified mail labels, I don't make any money. There's no affiliate link. I just happen to really, really like them. They're based out of Orlando, Florida. If you're a Disney fan, they're in Celebration, Florida, if you know where that is, just a little suburb of Orlando. You create an account, and what you want to do is you come down here to print and mail services. Now you have to have an account to do it. And then basically it'll say, all right, what document do you want to upload to us? How many pages is that? And then you approve it, you type in where you're sending it. And what they do is they print it and they mail it. Now they charge for that. Okay. So it's definitely cheaper to go to the post office yourself, but makes it super easy to track. You have sort of a dashboard, you can track your letters. And, we used to give people credit reports, dispute letters. We'd have them come to our office and we would say, okay, here's your letter, read it, approve it. And then we'd package it up for them and say, go take this to the post office. And we could never get the results of investigation. We're like, hey, Mary, where's your results of investigation? It's been 2 months. And then like at the 6-month mark, Mary says, actually those letters are still in the back seat of my car. I've been meaning to mail those. And so this is one way to just, if you can swing the extra dollars to do it, certifiedmaillabels.com. I think it's great. There's something called WordStream. I've never used them. I'm sure there are other services, but the point is either print this stuff out, go to the post office, address it by hand or whatever, or use a service like certifiedmaillabels.com. All right, let me go back to our slides here. And let's see. Lynn says you should have been a doctor. Yeah, my handwriting is horrible. Okay, I'm usually not in our Birmingham office, but my law partner Stan Herring, would come into me and say, "Hey, I can't read your handwriting," and I'm looking at him like, "I can't read my handwriting." Okay, so yeah, it's I maybe should get a side gig, like being the guy that writes the prescriptions, right? See, Derek says, is a return receipt needed? Yes, I like to pay for that. Now, whether you get the physical green card or you do the electronic signature, but I want the post office bill to say this was delivered, and I want to see a signature from somebody. Let's see. George says, yes, you proved they received what they say that the letter had no relevance, threw it away. Yeah, so I've never had that happen. I've heard maybe one time, and I've been suing companies since 1995, so it's been a couple of years. Okay, I think maybe I heard of one company saying, "Well, the letter you sent us was empty." I heard a guy used to be a former TransUnion executive or manager, and he said, "Oh yeah, we get dispute letters, and it's just empty certified mail envelopes." I'm like, who would do that? Maybe they did. Okay, I can't tell you what other people have done, but I can tell you like that certifiedmaillabels.com, or I'm sure WordStream or some equivalent. You have a PDF of exactly what you sent, and so there's not trying to like, well, I think this is what I did. Now, I'll say this: if you are mailing it yourself, keep a complete copy, okay? And don't sort of skimp on this and say, well, I'm not going to print out the attachments. No, print out everything. You want to be able to hold up in court and say, this is exactly what I put in the mail, okay? But again, that's one reason why I like using one of these services. And plus, it's easy, you give it to them and boom, it goes out. So pretty good. All right, so let's go to our next slide. So what should your letters say? So I've got a couple things sort of highlighted here, for identification. Well, who are we identifying? Who you are, who the debt buyer is, who the account is, and what are they credit reporting, okay? And then we want to explain the lawsuit. So talk about, here's the name of the lawsuit. So a lawsuit might be Midland Funding versus John Watts. Okay, well, where is that? Well, that's in the small claims court of Jefferson County, Alabama. Okay, well, what's the case number? Well, you put the case number down. What's the amount? What's the date that you got the lawsuit dismissed or a verdict in your favor? Just all the details. Okay. This is not the time to say, well, I'm going to be trying to be clever and say, go look up, there's a case somewhere in Alabama where I got sued and I won. Don't do that. Just give them all that information. Okay. Now, I like to tell the credit bureaus and I like to show the credit bureaus. So, what do I mean by that? We tell them that here's exactly what happened. And then we give them the documentation to show that. Okay. So we'll give them pages from the credit report. So we describe the credit report, but then we say, I've attached those pages for you. We tell them about the lawsuit, and then we show them by attaching the lawsuit pages. So hopefully that makes sense. And then we want to ask the account be deleted. You want to ask for what's called your full file disclosure. If you've been in this business or you've been doing research on your own, I'm sure you've run across this Section 609 letter. Generally, when people say that, they have no idea what they're talking about. Section 609 is actually a real section, okay? It just means you get to request your file disclosure. In other words, the information the credit bureaus have on you. Matter of fact, let me show you. I pulled up a couple of online things I wanted to show you here. So let's go to, let's see, section G here. So this is, we've got every consumer reporting agency shall give you all the information in your file. And then there's some exceptions here. So this is section 1681G. But there's another way to number this, and that is like this. So you can see this is literally section 609, but it's also section 1681G. It's the same thing, okay? It's like saying 6 or 1/2 dozen the other. So again, every consumer reporting disclose all the information in file. So you want to ask for that, okay? That in your dispute letter, you want to say, hey, give me my full file disclosure. So you not only get the results, but now you get a full credit report. A lot of times they won't give you all the information they're required to. Well, that's part of these lawsuits where we sue the bureaus. We say, not only did you botch the investigation and the furnisher messed up the investigation, and credit bureaus, you didn't use maximum possible accuracy. That's section 1681EB. A bad investigation, section 1681I. For the furnisher, the debt buyer, it's section 1681 S2B. And then we also throw in something from the FDCPA. But then we also sue the credit bureaus under this section 609 or 1681G. Hey, you didn't get my full file disclosure. So I would put that in there. And then you want to do lots of enclosures. Okay. I mean, just a lot of enclosures to prove who you are, to prove what you were sued for, to prove what's reporting. So you're trying to take away all excuses from the credit bureaus. And then definitely keep a complete copy. And we'll look at a template here, a Word document, then I'll share it with you so you guys can have it. Okay, so let's hear some more of my very fancy handwriting. My elementary school teacher would be, I'm sure, horrified to see my handwriting. But look, we want to remove excuses. So let's kind of play this out. So we do a dispute and we'll say it's with Midland. And the results come back. Midland has verified this to Equifax, Experian, TransUnion, whoever they're reporting it to. And so you sue Midland, you sue the bureaus. And the judge is, just imagine we're all in court and the judge is saying, well, Equifax, why did you not delete this account? I said, well, we didn't know he had been sued. His letter just said, I had a controversy with Midland and I won it. We don't know what that means. Or they go, well, he told us that he sued him, but we didn't know. Was he sued in Alabama? Was he sued in Kentucky? What was going on there? What happened? Like, who sued? Okay. Was it Midland? Was it somebody else? And so they're just making these excuses, but they're pretty good excuses because we've made it unnaturally or unnecessarily hard on the credit bureaus. So we want to just give them the information. And then they go, Well, yeah, he told us he got sued for $4,000 and it was this Midland account, but his credit report said it was $4,200. We assumed it was a different account. He didn't tell us who the original creditor was. He didn't say anything else. So we want to identify this is the same account. Here's the lawsuit. One thing, I'll share the story with you. So, like I said, we've been doing these cases for a very, very long time. And we used to not include the court papers when we would dispute. We'd just say, here's the court, here's the phone number, call them. And I remember the credit bureau saying, if you had just included, this is like their testimony under oath, if you had just included the court papers, we would have deleted it. Okay. I ain't the smartest guy in the world, but I can take some advice. So we started doing that with the disputes. They still don't fix it. We sue them and we go, hey, last time we talked to you, you said, well, if we only include the court papers, you would have deleted it. We did that now. They go, yeah, we assumed all those were forgeries. We assumed you just made up those documents. Really? Okay. So you'll see in our template letter, we say, we've enclosed the documents. If you don't believe me, call the collection lawyer, call the court. Okay. We're trying to take away their excuses. Okay. And then we want to enclose, if possible, copies of the credit reports. Now, sometimes you're locked out of a particular credit bureau, but it's on the other two, so you assume it's on the third. But do what you can, okay? And then prove that they received it. And what I have written in blue here, I think is very, very important. And I'm going to kind of draw a parallel with the other type of work I do, which is personal injury. So let's take a car wreck, okay? The case is really made by the car wreck, okay? I mean, either the guy ran the red light, either he was speeding, he was drunk, he was texting, he was doing something when he crashed into you, okay? These cases are really built on the dispute letter. If the dispute letter is solid, it's very specific, it explains exactly what you're looking for, what you want to happen, then that becomes a very powerful case. Now, it's a little different question than how much is the case worth. We might have the greatest dispute letter and the case is worth a small amount, or it might be worth 100 times that amount, okay? So there's still, we have to get into, and we're not doing that in this particular webinar, the value, but I'm talking about the strength of the case. In other words, did these guys violate the law? Did they run the red light? Were they texting? Were they speeding? Were they distracted? Well, our equivalent in the Fair Credit Reporting Act world is, what did your dispute letter say to them? See, the more detail you put in that dispute letter, the greater the obligation is for the credit bureaus. So imagine the credit bureaus. They get a dispute letter, you identify yourself, and they say to the judge, well, we didn't know this was really, Jason that was disputing this. Like, well, I gave you last four of my social, my driver's license, my utility bill. Matter of fact, I gave you lawsuit papers that showed I was served at, 123 Main Street. And judge is like, yeah, that ain't going to fly. So then they go, okay. Well, we didn't know it was the same account. Well, in my dispute letter, I identified exactly the account. I said there's a $183 difference in the dollar amounts, and that's exactly the amount of the filing fee. And the judge like, yeah, that ain't gonna work either, Mr. Equifax. And so then they go, well, we didn't know we were reporting it. Well, your credit bureau, you should know what you're reporting, but I actually included copies of your reporting. Oh, well, we didn't get it. Well, here's the certified mail. Here's the United States Postal Service saying they delivered it. Here's where you sign for it. They go, oh, okay. See, we're just anticipating all of their excuses, and we're cutting them off from being able to use those excuses. So when they get the lawsuit that you filed against them, and they're checking this out, and they're like, oh, yeah, that matches. Yeah, that matches. And they're like, we don't have our normal sort of room to maneuver, because they like to say, we never got the dispute, or you didn't identify yourself, or you didn't identify the account. It's like all those excuses go away. And now they've got a real serious problem here. Okay, so let me go to our next slide. So track your dispute. Obviously, if you do it online, you've done it. But you want to track it, whether that's through certified mail labels, whether that's through, just you have the certified mail number and you just plug that into the USPS website and you can track it. And if you track it, print that screen to PDF. So you've got that proof, because there's a certain period of time where you can't go back and get that information. And you don't want to say, well, before I sued, I don't want to be this way as a lawyer, or if you were a consumer involved in this, we wouldn't want to say, yeah, I looked that up and I'm positive it was delivered to Experian, but now I can't prove it. Just like take 5 seconds, print your screen to PDF, and then you don't have to worry about it. So what we're looking for is the delivery. Boom, 30 days. That's how long they have to get with the furnisher. I mean, actually, they have to get with the furnisher within 5 days. But all together, there's only 30 days for that bureau to respond back to you. Now, it doesn't mean you're getting a response literally in 30 days. You may, but they may take the full 30 days and then mail it to you. We'll see, they don't do it by certified mail. It might take 3 days or 5 days or 10 days. You might not get it. Okay. So we're going to talk about that, how we pull new credit reports after the time period for the investigation is over. Let me check our comments here. And again, I want to come back to, any of your comments, but I want to sort of keep them focused on what we're dealing with right now. Let's see. Derek says, what happens when they claim it was sent by a CRO, credit bureau, or I'm sorry, credit repair organization? So the credit bureaus cannot refuse to investigate just because it's from a credit repair place. Now, my recommendation is that at least if we're not dealing with credit repair, so like somebody comes to me, I'm going to have them send the letter out under their own name. Okay. But if you do it under a credit repair, or if the credit bureau suspect it's credit repair, that doesn't mean they can ignore it. Here's where there's some confusion. I know, Derek, you're not confused on this, but sometimes people are confused by this, because there's a provision that says if you go directly to the furnisher and they think it's from credit repair, they can ignore it. Well, we don't go directly to the furnisher because we can't sue them for that. We go through the bureaus. The bureaus notify the furnisher. And just because the bureaus think it's credit repair, they can't ignore it. They can ignore it if they think it's frivolous, but those are not the same thing. And they better be right. If they reject one of our letters and say, oh, well, we decided this was frivolous. Really? My driver's license, a utility bill, the whole court file, all your pages, carefully explaining in detail what's wrong, and you decided that was frivolous? Yeah, I would go to trial with them on that. And I'll say this, in all the years I've done this, I can't tell you how many dispute letters I've written, with clients. I don't think I've ever had one come back as frivolous, where they say it's frivolous. If they did, I'm sure I would have sued them for that. Okay. So just make sure your letter's not frivolous. Okay. Let's see. So, okay. So we'll come back again to those other questions. So what are the results of investigation? Remember, there's only two possibilities, right? It's deleted. That's fabulous. If it's deleted, you're really not going to sue the credit bureaus. Okay. And typically you would not sue the debt buyer, although there is an exception to that. We would not sue under the FCRA, Fair Credit Reporting Act, because there's no basis to do that. Because remember that little very fancy illustration there, you send your letter to the credit bureau, who sends it to a furnisher, they report back to the credit bureau. You can only sue if it's a lousy investigation. Well, if they delete it, then it's not a lousy investigation. Okay. So you may be able to sue the debt buyer under the FDCPA. So this would be a number of sections, but specifically section 1692E8. That's, so sort of think timeline wise. You win your case, and month after month, 2 months, 3 months, 1 month, whatever it is, after they lose, they continue to report saying that you owe the debt when a judge has said you do not owe the debt. Then we would sue them under the FDCPA. But what if they keep the account? Okay, so they don't delete it, they keep it. Well, I've written out, we sue the credit bureaus under EB, that's maximum possible accuracy, I, which is investigation. We sue the furnisher, the debt buyer, under S2B. That's when they're notified by the credit bureau, you dispute and they don't fix it, in this case, delete it, then they violate that law. And then E8, section 1692 E8, and that's under the FDCPA. So this is something that I usually call this the before, during, and after. Okay, kind of like a home improvement show. They show you the before, how's the house look. Then most of the show is the renovation, and then they show you the reveal afterwards, right? So think about this. Before is you have your credit reports, and you have your lawsuit, and you won your lawsuit. Okay. So that's what gets us to the dispute process. If it's not on your credit reports, there's no dispute process. If you didn't win your case, there's no dispute process. So assuming it's on your credit reports, you won your case, then you go into that sort of during section, and that's where you do your dispute. Okay. And then, well, what happens after that? Well, you get your results of investigation. Okay. And that's going back here where either they delete it or they keep it. Okay. And then we always like to pull new credit reports from manualcreditreport.com for each bureau, because maybe we didn't get results of investigation. I mean, I publicly have said this a number of times. I would say at least half of our lawsuits against Experian, they never responded to our dispute. It's their problem. They got 30 days to do an investigation. If they choose to just ignore it, well, that's a lousy investigation. Assuming we were right that there was false information here, pretty clear, I got sued, I won, and you're still reporting it, then they are just dead in the water on that. Okay. So we always want to pull, because maybe they did send it to us and got lost in the mail. Well, let's pull our credit reports and look. So we track the time. All right. They got my dispute letter. Now 30 days has gone by. I don't have results of investigation. Maybe I wait another 10, 15 days. Then I pull new reports. Is it corrected? Has it been updated? What's going on? All right. So here's a little checklist. I have like a real checklist for you guys. Okay. I think it's 3 pages long, but so was I sued? Did I win? Is there credit reporting on that specific account? Okay. By that debt buyer? Did I properly dispute it? And did it not come off? Hey, if all those things are true, then we're looking at filing a lawsuit. So here's something I want to talk to you. I don't want to go in great detail, and there are always exceptions, but this is something that confuses a lot of people. So this is damages. So if it's a willful violation, an intentional violation, a reckless violation, all those are the same thing for our purposes, then you can get what are called statutory damages. Totally different than the FDCPA. I hear even lawyers talk about, well, any violation of the FCRA, you get $1,000. That's not true. It's only when it's a willful, intentional, or reckless violation. Then you can get up to $1,000, and you can get punitive damages. So again, this is not the FDCPA. What we learned in the FDCPA sue and debt collector, this is totally different. Okay. FDCPA is what we call a strict liability statute. If they violate the law, that's enough. You can get damages. Here we have to show negligence, but just negligence is not enough to get statutory punitive. It has to be intentional, willful, reckless. But then put that aside, we get actual damages. Broadly speaking, that's economic and non-economic. What's economic? Well, I paid a higher interest rate. I lost my security clearance, lost my job. I missed out on, purchasing this house, and now the equity's gone up $80,000, whatever it may be. Economic damages. Non-economic damages are generally what we call emotional distress, mental anguish. It does vary some by where you live on how strict the proof is on that. Okay. But it's always available. It's just a question of, can you prove it? You just have to know your law and know how to properly prove this in front of a judge and a jury. And with the jury, that's also being persuasive. How do we convince people who don't know us to award, at least in our case, is very large, sizable mental anguish awards? How do we do that? Well, there's an art to doing that and a science to doing that. But first, we got to get past The judge has to decide that, yes, these are allowable damages. So when we're talking about actual damages, a lot of times people say, hey, I lost out on that home loan because I figured out there were errors, and then I disputed it, got fixed. I want to sue for those errors. Well, it depends on what type it is. Usually, though, if it's based on an investigation, we only get damages from the point of the investigation going forward in time, not prior to that. Now, again, there are exceptions, there are different ways to handle this, but just sort of think, here's the sort of the most conservative way to think about it. I saw errors, I disputed them, they did a lousy investigation and kept them. Boom, from that point going forward, you're pretty solid on your damages, okay? And so some free resources, dispute letter, checklist. I know not everybody's on their computer and can download this. Just reply back to the email that led you here, because you had to get an email to come here, and I'll attach those to an email. So let me, before I pull those up, let me look at our questions here. And let's see here. The Tony asked question, if CRAs delete the trade lines but don't mail you the full file disclosure, would you sue under that? I'm trying to think if I've ever sued just for that. I want to say I've always added that on top of other things. So I guess it would depend on how lacking the full file disclosure is. Did they just not send it to you at all? Did they send it to you and it was missing half the information? But generally, I kind of pair those up with other claims. Good question. Let's see. Okay, Lynn asked a great question. How best keep track of dates and times, a spreadsheet? You can, or I'll give you a very simple like Word document. I'll share that with you in just a moment here. Okay, so let me share a couple things here. So I'll tell you what, we'll start with the checklist. This will be a PDF, I believe is what I'm sharing. And then I'm going to share it with you in a Word document. And again, if you miss this or if you can't get it because you're on your phone or whatever, just email me and I'll send it back to you. Let me pull up the Word version of this. I'm sorry, the PDF version of this little checklist. And we'll just kind of walk through this. Okay, so I'm making it so you can see the whole page here. Hopefully you can read it, and we'll get into a little bit more detail, but it's just very simple. Like, did you receive a defense verdict or a dismissal of prejudice? Do you have your actual reports? And then can you match that? I know I keep harping on that, but I mean, I have lawyers come to me and say, John, I got this great case. I know you love these cases. Boy, we got them this time. You know, we did the disputes, everything. And I look at it, it's not the same account. I'm like, we don't have a case. They're like, oh, I was really thinking we had. I'm like, no, we have to match it up, you know. And for consumers, I understand what happens. You know, I got sued by Midland, and 6 months later, I open up my credit report, and there's Midland on there. I'm like, I beat you guys, but we've got to make sure it's the same exact account. Okay, so there's just a lot of detail here about that. And then, do you have your documents? And let me sort of make this a little bit bigger here. So, you know, here's the information about matching it up. You know, circle which reports is this showing up on. You know, this is just something to help keep you organized. Now, maybe you don't need this. There are some people who are like inherently organized. That's not me. Okay. So I have to sort of compensate for weaknesses here and say, all right, well, let me put all this information down on paper. And then do you have the documents? Do you have a driver's license, utility bill, something to explain or show where you live? And if there's some discrepancy, or if you have multiple addresses, you know, some people say, well, I live here, but I get half my mail over here. And here's where my utility bills are, but my driver's license is this one. Well, just explain that, okay? Do you have the lawsuit? You know, some people say, well, I don't have all the copies. I'd have to go to the courthouse, or I'd have to request it, or they're going to charge me 25 cents. Well, first of all, I would say this. my recommendation is even this dispute process, get a lawyer to help you. Okay. Uh, I'll say at least the way we do it. If somebody comes to us and they say, hey, I got sued, I won, I got dismissed with prejudice, will you help me dispute it? Of course, we'll help you dispute it. That we love doing this. Okay. Uh, but if you're doing it on your own, and by the way, we don't charge anything to do that. Okay. We never charge anybody to help them dispute items on their credit report. I make my money by suing the bad guys. That's where I get paid, is by the bad guys when we sue them. So, but if you're doing this on your own, like, again, don't skimp on it. Like, go get the whole court file. Okay. Get all the paperwork you can. Do you have proof of service? In other words, where they say, hey, I served you with this lawsuit. See, sometimes it'll have your address. I served, Bob Smith at his home address of 123 Main Street. Hey, that's another proof that that's really your address. Okay. How about your answer, your response? How about the relevant pages from the credit report? And then we'll look at the second page here. All right, so this actually page 2 and 3, but the dispute letter itself, and then keep a copy of what you sent. Okay, so let's kind of drill down into this a little bit. So, do you have the correct credit bureaus? If it's not reporting on Experian, don't dispute it with Experian. Have you verified their addresses? I've got some addresses on there, but don't trust that. Go verify that this is literally the correct address. I do this with every dispute letter my firm's involved in. On the day we mail out the letter, we go PDF from Equifax's website, Experian, TransUnion, et cetera, this address. So if they go, well, actually, we changed our address. We're like, well, you didn't change it the day I mailed it. Okay. And I'll say this, my memory is Experian's the only one that every few years they change their address. Okay. Just always check. It's just a good habit. If you identified yourself, the debt buyer, the account, the credit reporting, explain the lawsuit information. So I just want to give you something so you can go, yep. Okay, we did all that. Do you have a full copy of what you sent out? You're doing it certified. Okay. And this was, I think Lynn was asking about, like, how do you keep track of all this? You certainly can do it on a spreadsheet. That'd be, pretty easy and visually easy to see. But I just wanted to make this, as absolutely as easy as possible. You type this, you print it out, you handwrite it, whatever. When did Equifax get it? Experian, Innovis, TransUnion. Then did they respond? Okay. So you write the date and then you just circle. Did they delete it or did they keep it? So who are you looking at suing? And this would be the debt buyer down here. So that's the second page. The third page is really about, okay, if we're suing, and some of you who went through my 6-part webinar series on, how do you dispute all sorts of errors on your credit report, you'll recognize this because this is pretty much just taken from that. But it's just, are you confident in this lawyer? Do you feel comfortable? Does this person have experience? Now, you don't have to get somebody with experience, but you should know that hey, somebody says, look, I've never sued the credit bureaus before, but I think I know how to do it. Okay. You may decide that's great. Or you may want somebody who's experienced, keeping up with the law. Do they teach about this? Can, they make this understandable to you? And then any questions you have. And so you have this one document, either it's on your computer, Word, PDF, or you print it out and you got 3 pages, just staple it together. And as you're going through this process, that can help keep you organized. Now, again, there's a lot of people, they can stay organized up here, but for the rest of us, it's helpful to be able to say, oh, well, I've got these pages here. And as you're thinking or researching or figuring out what you want to do, you may say, oh, here's a question I want to ask. Well, write it down. Don't try and remember it. There's an old expression that says something like the faintest ink is stronger than the best memory. Okay. Write it down. All right. And so that is the checklist here. Let me stop this. And so Kenneth, on that document, you should be able to just click on it on the screen. If you have any problem, just email me and I'll get that to you. And then I want to share the template letter. Go back. And this is in a Word version. And so let me pull up this document here. Let's see here. Let me get this moved over to the correct screen, and we'll take a look at this. And again, if you weren't able to get it, no worries. We will be able to get this over to you. Okay, so here's the, let's see. That was actually the wrong one. Okay, so this is what you should be able to, you should be able to, this is what you should be clicking on here. So I know this is sort of obvious, but honestly, I've had people like leave all this stuff on there. Like this stuff up here, these are just some instructions, right? And anything in red is saying that's where you put in your information, or that's just like a question to you. So I remember this back when we did a lot of TCPA litigation, Telephone Consumer Protection Act. So we're suing for robodial calls to cell phones. And we gave our clients a template letter. And it says like, if don't ever call my cell phone number of XXX-XXX-XXXXX. And so client said, hey, I sent the dispute letter out, and boy, they've called me like 74 times since then. And I'm thinking, oh, this is awesome. Because that could be $1,500 per call. I mean, we've had some TCPA cases with hundreds of calls. You can imagine what those cases are worth when you're doing like $500 per call or $1,500 per call. Very large six-figure cases. And so I'm so excited about it. And I said, you sent the letter? He goes, yeah. I'm like, you got proof of it? Yeah. And I'm like, oh, this is great. Let's sit down and talk about it. And I made the mistake of not looking at the letter because he kept a signed copy of what he sent. But, I was like, well, I know what the letter said. Well, then like at the end of the meeting, I look at the letter and it says, do not call my cell phone number of XXX-XX. And I'm like, He goes, I didn't know. You didn't tell me I needed to put my number in there. I'm like, well, that's true. I didn't say that. So I'm being very specific here. The stuff in red is really for you to make sure that this is correct. So, you put the date. Obviously, you put the bureaus that you're disputing and you verify their addresses. Okay. And then, hey, I'm asking you to do three things. Number one, give me my complete file. Number two, I only want this personal information. And if you went through my webinar series, and if anybody didn't, you're welcome to just email me. I'll send it all to you. But we do a little bit more involved dispute process for our personal information. This, I'm trying to keep it relatively simple. Here are the correct versions of my name. So, if you only have one, you say my name is. If you have multiple, my names are, and then you list those: date of birth, social security. You just put in your last four. I personally don't put in my full social unless there's a problem with the social security number at the credit bureau. And then again, this is my one address, or these are my addresses. And just explain, like, my driver's license has my parents' address, but I live over here in this apartment and I get some mail. I mean, just explain it. Just, there's no magic to it. Just, explain it in words. Remove all the other stuff. I don't want that. And then third, so remember, first was I want my full file disclosure. Number two, I want this personal information corrected. Number three, I want you to get rid of this account. Now, sometimes we do this and we may dispute 10 other accounts. Okay. But that's that's a 6-part webinar series on that. Okay. So I'm keeping this very focused for our purposes. If you're just disputing the account that you got sued on and that you were successful in. So I want it to be accurate and complete. And so you put the debt buyer name. So Midland Funding, Midland Credit Management, Portfolio Recovery, whoever it is. You put the account number. You may get some of that from the lawsuit. You may get part of that from the credit bureau. Again, just sort of put it, 1, 2, 3, 4 XXX is from the lawsuit, and credit bureaus you're listing, XXXXX-5789, whatever it is. Okay. The balance. this would be what is being reported and the original creditor. So Synchrony, Community Bank, Capital One, who has it? All right, so this account must be deleted as I have never and do not now owe debt buyer. Again, you type in the name of the debt buyer, any money. This is supposedly a debt from, and you type in original creditor, Capital One, Synchrony, whoever it is, as follows. Usually in the lawsuit, it might be one sentence, it might be a whole paragraph, but they'll describe, this lawsuit is brought because defendant, that would be you, defaulted on a Capital One account ending in 1234, opened on such and such day. I mean, whatever information they put, might be a tiny bit, it might be a lot. I would just copy and paste that in there. Then describe the lawsuit. The lawsuit, that debt buyer, again, you would replace that, filed against me as the following. Here's the name. So debt buyer versus, now I'll say this, sometimes it may be, Midland Funding, Midland Credit versus Ruth Smith, but Ruth Smith is now Ruth Jones. Okay. Well, don't put your current name, put the name you were sued under. Okay. Debt buyer versus Ruth Smith. Now you may want to put a parentheses and say, that's my married name. I'm now divorced. I've taken my maiden name back, whatever it is, like just describe it. You don't want the credit bureaus or a judge reading this letter to kind of get lost and go, well, wait a minute, lawsuits against, Ruth Smith and you're Ruth Jones. Are you the same person? Well, explain that. Okay. The name of the court, a small claims court in the county of, or however your state does it. Okay. And obviously, look, I practice in Alabama, and then Blaine, who's of counsel with us, practices in Tennessee. But wherever you are, I'm not giving you legal advice. I'm giving you some general educational material here. You obviously have to use your own judgment, talk to a lawyer. But your state may call them, a parish or something else, like whatever it is. Okay. Describe the court. Usually across the top of the lawsuit, it will say in the blank court for blank county, Alabama, Georgia, Tennessee, wherever. Put the case number. Somewhere there's a case number on there. Some people go, well, should I put the whole case number just like the last two did? Yeah, put the whole case number. Because you want to take away all excuses from the credit bureau when they say, well, we didn't know really what this was. Okay. Or there was no way we could have contacted the court. Yeah. I told you the court name, the county, the case number, everything, right? The collection law firm, the suit was brought by XYZ collection law firm. The amount sued for, $4,000. And then you say, this is the same debt that each of you are reporting. And then you explain if the amounts are different. So, I mean, sometimes we go into a lot of detail with this. We're like, well, look, we pulled from the court file the exact filing fee plus convenience fee plus blah, blah, blah. And if you add that to the amount they sued me for, you get precisely the amount that's on my credit report. And again, we go through the history of the credit report and say, see, it changed. It was $4,000. And then when they sued me in June of last year, it went to $4,200. $200 is the filing fee. And so we're tying all this together so there's no excuses from the credit bureaus. And you talk about the open date. Remember, the open date, as they describe it, is when the debt buyer received the account. Well, sometimes attached to the lawsuit is an affidavit saying, here's when we received the account. Hey, look, these match up. The original creditor, just again, no magic language, just type that out like you were talking to somebody. Somebody goes, hey, prove to me that's the same account. Well, just however you would say it to them, whether it takes a sentence, a paragraph, or 5 pages, like however long it takes. And then you say, this account must be deleted. Debt buyer, again, you plug in who that is. Sued me. I won the case on whatever date. Court dismissed the case with prejudice or ruled in my favor, whatever it is. This means I do not owe the debt. I want you to get this, Midland account off my credit reports. I don't know why Midland or whoever has not already removed it. I want you to step up and do this. I'm enclosing papers from the court file. If you don't believe me, remember we had them under oath. They're like, if you just enclose the court papers, next time we sued them, they go, well, we can't trust anything that you sent us. We assumed it was all forgeries. Okay. If you don't believe me, contact the court. Well, again, we're taking away excuses, right? They go, well, Judge, we assumed it was all fake. And, we wanted to contact the court, but he didn't tell us what the court was. See, we spell it out. It's obviously in the papers too. You don't have to spell it out in the letter, but I like to. Okay. Contact the court, contact the collection lawyer. They go, well, we didn't know who the collection lawyer was. Well, it's on the lawsuit papers, why we enclose them. Okay. Get your own copies. Thank you for fixing this by removing again, you put in Midland or whoever account to make my credit report 100% accurate. Enclose my driver's license, proof of address or multiple addresses, court documents, pages from credit reports showing the Midland account. Put your name, put your date of birth, last four social, address, and that's really the letter. Okay. Now, obviously, if you're sending this out on your own without talking to a lawyer who does this type of work, you make your own decisions. How do you want to modify this letter? I'm just trying to give you a starting point so you're not really staring at a blank page going, well, I don't even know where to start. And I wanted you to have that little checklist to say, okay, let's make sure that we've captured everything. Now, I'll say, in my firm, we've built out software and all that for this. So, it's already built into that. Okay. But I wanted to make this for you. And so I just sort of created this letter, check it against the checklist. Maybe I left something out. That's why we have a checklist, to make sure that we're including everything. Did we explain the court? Did we explain the date? Did we attach the documents? All that sort of stuff. So that's really what I had for you guys. And let me go back to our questions here. And if you have anything specifically on, what we talked about, go ahead and drop that into the chat and I'll pick that up. This is different than when I do like YouTube or Facebook Lives. There, I'll put the chat like on the screen. Here, that it won't be, on the screen. I'll just read it. And then I've got a little bit of time. I'll try to go back and grab even the questions that are a little bit unrelated, but I wanted to make sure if you have any questions about you were successful in your lawsuit where you were sued by the debt buyer. Again, we'll talk if you want to next week about what about when an original creditor sues you and you pay them some money, how do we make sure the credit reporting is accurate? Okay. It's really a different process than what we're doing here. But if you have questions about this, how do you do the dispute letter? What do you do if they haven't fixed it? Go ahead and drop those in. And I'll tell you what, I will start back at the beginning here and try to grab the questions. Let's see. Merle asked about, has been trying to reach me. Yeah, I have been, we had a jury trial going out and then a bunch of non-jury cases. So it's been a little chaotic, but I apologize. I haven't gotten back with you. And Merle, if I remember, I think you're in Chicago and actually I have a lawyer there. If my memory is right, that you're in Chicago. I've got a lawyer there that I think can help you. So get with me on that. And I'll try to go back through my emails, but if you don't mind, just reply to the email that led you to this webinar and I will get with you. So Jessica says, thank you for your time. You're very welcome. And then my friend from Puerto Rico, who it's ironic, we ran into each other in, let's see, Orlando and then Phoenix, Arizona. We're both constantly learning about this stuff. And so it's great to see you, Ignacio. So some of these I think I have covered. Oh, here's one from Deborah. Can debt buyer report a charge off my credit reports without filing any formal lawsuit in court? Yes. So a debt buyer who truly has bought the debt, now they own it, they don't have to sue you. Matter of fact, it may be too late for them to sue you, the statute of limitations. They can definitely credit report as long as they're credit reporting, I would say three things. One, it's accurate. And second, it's complete. And third, it's not beyond the time period to credit report. So what a lot of people do is they confuse, I'm not saying you did this, Deborah, I'm just saying a lot of people confuse two really important concepts. One concept is the time period to sue you. That's statute of limitations. Okay. That can be extended based on your state law. If you maybe make a payment or promise to pay, it depends, but you may be able to extend that time period to sue you. And that time period varies greatly among the states. it might be 2 years. And the neighboring state might be 12 years. Okay. This has absolutely nothing to do with the time period they can credit report on you. So statute of limitations, time period to sue you. Time period to credit report, we call this the obsolescence period. It's basically 7 years from the date you first went delinquent and then never recovered from that. And it doesn't matter if the debt's been sold 1,000 times. It doesn't change that 7-year time period. So if you defaulted and never recovered, January of 2016 with Capital One, and they sell it to all these debt buyers who sell it to each other, all these people, it still has to come off within 7 years of January 2016. There's really nothing you can do to prolong that. I mean, even if I wouldn't advise it, but if you send them a $20 payment, that's not normally going to extend the time period to credit report. It might extend the time period to sue you. So you have to be careful. You might be talking to a debt collector and they say, well, just show your good faith. I just need you to make a token, a nominal, just a good faith payment, $5. Just send me $5. Then we'll know you're serious. Okay, that sounds reasonable. You send $5, and now they go, aha, you just restarted statute of limitation. Now we're suing you. We couldn't see you before. If they do that, we can probably sue them because they lied to you, okay, by not telling you what the effect would be. But just you want to be careful, okay? So Harry says, if a joint account is disputed by one owner, should the dispute results show on the credit report for both owners or only the owner who created the dispute? That's a really fascinating question, Harry. I've never had that question. I've never thought about that. My gut feeling is that it should show up on both of them. In other words, if you and I have a joint Capital One account and I dispute it, well, the account is disputed, okay? Even though you haven't disputed it, I think it should show a dispute notation. Just like if I'm the one paying it, but I failed to pay, that 30-day late is going to be on your report too, okay? Because if we own it jointly, we're jointly responsible for it. And now it gets a little complicated with bankruptcy, okay? That's a whole nother subject, but I would say on your question that it should show as disputed. All right, let's see. Jessica says, found so many violations, but to hear back from consumer attorney is an attorney, what's the best way to have attorneys taking the cases? So Jessica, I would say two things. One, if you're a consumer and this is your own case, that's a little different than if you're like a credit repair place and you're finding violations and wanting to work with lawyers. Generally, lawyers that do this type of work are more inclined to work with consumers directly, okay? And I'll explain that in just a second. But if you're a consumer, it's really just being able to lay out in an organized way, maybe even that checklist. Here's what happened. Here are the violations. What is frustrating is, I'll get people saying to me, hey, John, I got all these violations. Will you take my case? And I say, well, tell me what the violations are. And it's like, John, I have researched this carefully on the internet, and you don't need to know what the details are of the violations. I just want to know, will you take my case? I'm thinking, okay, I've been suing the credit bureaus for 20 years, but what do I know about this? I'm sure somebody in a weekend figured this out. And say, well, I need to know the violations and I need to see your credit report. I'm not showing you my credit reports unless I know that you'll take my case and tell me the value of it. And I mean, this has been like twice I've gone down that route. Usually I cut it off at the very first. But the point is, if you want a lawyer to do this, and there aren't many of us that do this type of work, you got to lay it out, in an organized way. Not, here are 573 pages, and if you will go through and study it, you'll find a violation. No, tell me. Like, have you done the disputes? Did you get the results? Can you prove that the bureaus got it? Can you prove what you sent the bureaus? Do you have updated credit reports? Or is it you want me to do the disputes? Well, maybe I will, maybe I won't. Okay. I need to know, what are we talking about here? So I would just be very, very specific with the lawyer. Now, if you're a credit repair place, here's the problem that you're going to have, at least with a lot of lawyers that do this. First of all, some lawyers that sue credit bureaus view credit repair the same as the credit bureaus. Hey, if I can sue a credit repair place, that's great. That's not my view. I'm just saying that's sort of the predominant view among consumer attorneys. The idea being there's so much fraud and corruption among credit repair places that probably they're ripping somebody off. The second thing is, I don't know, maybe once a week, I have a credit repair place reach out to me. Hey, John, we have hundreds of cases. We love your videos. We love your articles. We've looked at your lawsuits. We want you to represent our clients. Okay. I'd say, I need to see how you're disputing things. And it's just complete garbage. Like the letter will say, there are inaccuracies in my credit report. Please verify all negative information. Otherwise, delete it. They go, see, they didn't do it. Sue them. I'm like, that's garbage. We can't sue on that. Or maybe they do actual legitimate disputes. And then the next question is, well, Mr. Credit Repair, Miss Credit Repair owner, are you looking for money for me? They're like, well, yeah, of course. I want to sell you my clients for, $1,000 a client or whatever. I can't pay a non-lawyer any money on a case. It's unethical to do that, at least in my state where I practice. They say, well, I want to, sell you the leads, or I want you to make sure the client pays me half of what they get out of the lawsuit. You're not the client. You're not the lawyer. Okay. So that usually makes most people go away. But if I have a credit repair place that says, look, John, we make our money by doing credit repair. If there are legitimate errors and we can't get it fixed, we send it to you. We're not trying to get any money out of it. We just want you to take care of our client. Okay. Now we can talk. But if you're approaching as a credit repair place, a consumer lawyer, I would be very upfront and very specific about this. If you're looking for money, then say that. If you're looking for, you want a percentage of what the client gets, which frankly, I don't think is legitimate to do that, say that. Okay. I'm sure there are lawyers that would work with you on that. But if you're not looking for that, say, look, I run a legit credit repair place. We do actual disputes with the errors that we find, the factual errors. And when I can't help people at the end of the day, I want to give them a name, and I'm not looking for anything from this lawsuit. I don't want any money out of it. That would be just between you and the client. Well, then I think you'll get a good response there. Okay. Let's see. Sasha says, really appreciate all your excellent videos. I've learned so much. Well, hey, I'm glad about that. Is the original creditor required to mark the credit report as disputed if they sue and an answer with denials is filed in court? I would say so. It's certainly true of a debt buyer who's a debt collector subject to the FDCPA. You file an answer denying that you owe the money, then they have to mark your account as disputed. But that's under the FDCPA. Under the FCRA, you can, there is a concept, although it's a little more strict, it has to be a bona fide dispute. Then the furnisher, the original creditor, has to mark the account as disputed. And that gets a little involved over what can we sue on, what can we not sue on, but at least get you started there. And what's the best way to request the FCRA spreadsheet? Send email. I realize very busy. Yes, Sasha, sorry if I didn't send that to you. I will say this, that sort of lengthy 6-part webinar series, I'm planning on redoing that, making it a little simpler. There are some ways I think that maybe it won't take quite so much effort. Now, I will say this, I've had people go through there, had great results. Either stuff gets fixed or deleted, or they're in a position where we can sue. And so, that's certainly fun to see. But also know it's a little overwhelming. So I may do a little bit sort of lighter version of it where, maybe a few less moving parts. But Sasha, if you want to just reply to the email, I'll get you that spreadsheet. Let's see. Jason says, if a junk debt buyer sues you and you respond, then there's no action, and there's no action. It's now 18 months later. Is there anything you can do to resolve the issue? You just have to wait. So this is where every state, and sometimes even within every state, each county can be different. So I'll tell you the general rule in Alabama. Let's say that you're sued for a $5,000 Midland case, and you answer, or you hire me and I answer for you in Alabama. The moment that answer is filed, typically within like an hour, we have our trial date. Now, not like we're trying the case in an hour, but within an hour, we get an order. Everything's done electronically in Alabama. We get an order saying your trial is set, and usually it's 3 to 4 weeks away. Now, my friend and sort of cohort, Mr. Blaine Dixon in Tennessee, what happens there is they have a hearing schedule. That's not the trial. And I don't know, Blaine may be on this call. He can correct me if I'm wrong. But you go to that hearing. Now, if you don't show up, you lose. But if you go to that hearing, then you get a trial date. A friend of mine, Mike Cardoza in California, I think he said they're getting trial dates like maybe a year and a half after they answer. Okay, so it varies greatly. I want to say in Mississippi, the judges are a little more, hey, we'll let the lawyers sort of control the schedule. So they're going to be kind of passive until somebody says, hey, judge, we want a trial date. In Alabama, almost every county, they're like, no, here's when your trial is, and it's coming really, really fast, okay? There's no right or wrong to it. You just have to know your area. So I would check with the lawyer in your state that defends these types of lawsuits. And if you don't know anybody, let me know. I may know somebody. I know, a good percentage of the lawyers that do this type of work. And they can tell you what to do, or you may just have to wait. One thing I would check on, just a little tip, is if you answered, and not every state requires you to answer, but if you answered disputing or denying that you owe the debt, check your credit report. Is Midland or Portfolio, have they updated your credit report since they got a copy of that answer? And have they marked it as disputed? If not, maybe a violation, be section 1692E8 of the Fair Debt Collection Practices Act. Let's see. So Murley says, if you win the case against original creditor when the original creditor debt collection lawyer unable to prove due to lack of documentation I had an account with the original creditor. In this scenario, if you go to federal court and sue the original creditor for the credit bureau's misreporting, does that mean you admit owning the account with the original creditor? So I'd say this. Let me give you a couple scenarios because I'm not 100% sure. So let me give you like an example. Capital One sues you. You win. Okay, I don't mean like a dismissal without prejudice, but I mean dismissal with prejudice, or you get a verdict in your favor. Now, it might be because they can't prove it. In a way, it doesn't matter. When it comes time for trial, everybody's got to show up. I could step into the ring with, the heavyweight champion of the world in a boxing match, and he doesn't show up, I win. Okay. Doesn't necessarily mean I'm better than him, but it means, hey, he didn't show up. He lost. You got to show up when it's time. So in that situation, we would treat that exactly like we've been talking about in this case. And I've had that with original creditors that we beat at trial. So, hey, I got sued by Capital One. I won my case. Get it off my credit report. Now, see, they would go, but you really owe the debt. No, actually, I don't, because the judge says I don't owe it. Just like if you were sued on a debt you do not owe, but you lost, you can't go to the credit bureaus and go, I know I lost, but I mean, truthfully, I don't owe this debt. They're like, a judge has decided. Okay. Now, if what you mean is a debt buyer sued you and they couldn't prove it, well, that the fact that you beat Midland or LVNV really doesn't have any impact on like the Capital One reporting. Okay. Now Capital One, if they sold it, should be a zero balance, but Murley, get with me. And again, if you'll remind me where you are, I think I have a lawyer there that can help you. Okay. So Tony says, we covered that. They delete the trade line, don't do the full file disclosure. Then yeah, maybe we can sue for that. Let's see. Robert says, just for me to understand, get a perspective, I'm not the only fool that got himself in this crazy debt. 6 creditors I defaulted on. What's the percentage of Americans you believe find themselves similar situation? I know I'm not alone. Yeah, you're definitely not alone. And I'll say this, my view was in 2019, we were heading to a recession. Obviously COVID hits and we did go into a recession, but we went into it because of COVID. And then like all the rules got changed, right? I mean, what the Fed did with, not to make this boring, but they just flooded the economy with unbelievable amount of money, cut the interest rate so low, artificially low. And so, and then we had all the stimulus checks. And look, whether all of that was good, bad, indifferent, it doesn't matter. It's what happened. And so Americans were pretty flush with cash because we had hundreds of thousands of people not paying their mortgage. I mean, I think LA County, the eviction moratorium has been extended to June of 23. So you could be 3 years without paying your rent, okay? And you can't be evicted. So there was a lot of cash that consumers had. So credit card debt went down, okay? So what should have been this financial disaster because of what Trump did, because of what Biden did, it wasn't a disaster. It's kind of this economic boom. So stock market, crypto, like everything goes crazy. Housing prices are just off the charts. Well, at some point, there's a price to be paid for all that. We're paying that now. We've got inflation raging out of control. So people are massively using credit cards. And so that's a long explanation, maybe longer than you wanted, but that's a long explanation for there's a lot of people in your situation. And, lawsuits may have been held off a little bit because of the pandemic, but we're seeing those come back. Now, Alabama, only the original creditors held off for a little while, and then they've been going, full blast. But we're going to see more and more. There's a massive car bubble. Okay, unbelievable amount of car debt. People way overpaid for cars. There's going to be lots of repos and deficiency lawsuits. So I would say this: you're not alone, and you can't change the past. Just start looking at it now. If you're in Alabama or Tennessee, get with me. If you're in another state, let me know, and I'll see if I can find you a lawyer there. But I would talk with a consumer lawyer. Okay, what's the game plan? Do I have errors on my credit reports? Do I have debt collectors coming after me? In my state, do these original creditors sue, or do they sell the debt? Do they not sue and not sell the debt? There are some of those. Okay, so you really need to get a handle on where you're at. Sort of like GPS, you have to know your current location to know how to get to where you want to go. So are you dealing with creditors, debt collectors? Do they sue? Do they not sue? I would get with a consumer lawyer in your state. Let's see. Harry says, dispute account May of 2020 with Equifax verified correct with modification. They showed a current repossession in May 2020 on an account that was paid in full for voluntary surrender, but they report as a charge off. Is there a statute of limitation? Well, if you paid it in full, there should be a zero balance, and you can't be sued for zero. So statute of limitation wouldn't come into play. I guess my question would be, is it accurate what it's saying? In other words, whenever it says there was a repossession, is that accurate? And so we just take each little piece of that trade line or that account. And I do have a couple things. You can find them on YouTube. I think I call them like master class on charged off accounts. There's 2 parts to it, pretty lengthy ones, but just showing how we go through just literally like data by data on each field of a credit report to find the errors. So I would do that. And now if when you said statute of limitation, if you meant how long can they sue, that all goes back to when did you first go delinquent that you never brought it current, making normal payments. Okay. So I'm not sure when that happened, but paying it off would not change that date. Okay. Let's see. Derek asked, list of questions to determine damages. To some extent, I mean, that's kind of, getting into the details of how we get clients ready for depositions and trials and stuff. So that's not something we really make public. Kenneth asked about my email. Yeah. So let me give you the easy one here. So it's just johngwatts@gmail.com. And that goes to my business email. It's a little bit easier. The business one is john@wattsherring.com, but they all go to the same thing. Let's see here. Sasha's 6-part series was fantastic. What's the best way to request spreadsheet, etc.? Yeah, just email me and I'll send you an email back that will basically have links to all those videos and then links to all the handouts that we had in those. Tim says, what happens when a CRA reopens an account? Let's see. So I'm not sure what you mean by that. If you're talking about it was deleted and then they reinserted it, or maybe give me a little bit more detail on that. Let's see. Harry says joint owner's account does not show dispute. Many other items still dispute. You recommend anyone in Indiana? So get with me on that. I may have somebody in Indiana. Actually, I may have a couple of people. So just email me your situation and I'll try to connect you with a lawyer too. See, Tim says, I used your concept coupled with a Prodigy Surge Metro 2 attack. TransUnion claimed I was third party, gave me no results. So, okay, let's kind of talk about what this is. So, Prodigy, as I understand it, is some software that is built upon Metro 2, which Metro 2 is the literal language that's used to sort of how do we get information from Capital One to Equifax? Well, it's, just like a series of numbers. Okay. So just think of it kind of like a computer language, and there are rules to what's required. So normally when people talk about Metro 2, they're really talking about the rules that are in what's called the CDIA, um, Consumer Resource Guide. I forget the exact terminology. Most people just call it the Metro 2 manual. And that gives the rules, but the actual Metro 2 language is a series of numbers here. So there's a sort of a school of thought that you can attack things on the credit report with Metro 2. Now, I'll give you sort of the two versions that I'm familiar with. One version, and this would be like Stephen Palmieri, who I do a show with every couple of weeks called Legalese. What he's doing is saying, okay, what are the rules of Metro 2? And hey, they're missing this data or this conflicts. And so he's approaching it that way. He calls it Metro 2. His approach and my approach would be very similar, not exactly the same, but very similar. I just call it factual. Okay. We're going in and finding, sort of regardless of what Metro 2 says, because that's not the law, but we're saying factually on the credit reports, these are wrong. Like, give you an example. TransUnion says your date of last payment was September 1st, 2019. The amount of last payment was zero. Really? I paid zero? That counts as a payment? Zero? No, see, it's contradictory. It's nonsensical. Okay. I really don't care what Metro 2 says. All I care about what's reporting on my credit report. The other approach, and I make no claims to understanding it, I've just sort of seen it in passing, is this idea, and I may be mixing sort of a few of the players in this field, but it's sort of like we're not disputing, we're attacking, we're requiring some proof of compliance with Metro 2. I'll just say what I've seen of that, it doesn't make much sense to me. And again, I haven't dived into it, but it's not something I would sue on. In other words, a judge has to be able to read the letter, the dispute letter, and say, I get it. A jury has to be able to read it and go, yep, I get it. And the credit bureaus didn't fix it. So I don't know exactly what's involved in a Prodigy Surge 2 attack. But anyway, they say they're not going to give you the results because you're a third party. So credit bureaus have to process disputes from a third party, like a credit repair company. You have to show the credit bureau that you are authorized to receive those disputes, to make the dispute, to receive the results. Generally, people do that through a limited power of attorney. And, I, John Watts, authorized Tim to act as my limited agent to send disputes, to receive credit reports. I'll say this. Sometimes credit bureaus don't honor those as far as sending the results. Usually, if they won't accept it. They'll accept the dispute unless they think it's frivolous, but they'll send the results to the client. We'll just have the client scan it to you or mail it to you, would be my idea. I mean, I certainly, at least as I sit here today, I've never sued the credit bureaus for not accepting those, and it's not something that's on my agenda. Now, again, it's not my approach. My approach is, the consumer makes the dispute letter, the results come back to the consumer, and then if it's not fixed, then we sue. So I don't do like rounds of disputes and all that. We do a dispute, it gets fixed, great. If it doesn't, we sue them. Now, sometimes there's a good reason to do multiple rounds of disputes, but we're not doing it because we have to. We're doing it because maybe they modified something and now we want to dispute that. And the more rounds of legitimate disputes, generally the more valuable the case becomes. But I find cases are pretty valuable with one dispute. All right, let's see. Kenneth says, Project 2 Metro, can you explain? Kendra asked about the name of the lawyer in Chicago. Just get with me, Kendra, because there's a couple people, kind of depends on what we're looking at. Everybody has sort of different specialties. So just if you reach out to me and say, hey, here's my situation, then I can help you with that. Murley, in Chicago, send an email later. The discoveries in the initial stages in the case management meeting, would you ask for a trial date to be earlier or later? What would your strategy be in debt collection lawsuits? So if we're talking about, I've been sued by Midland. Now, I take probably a minority view on this and a number of things. I'm always having lawyers come up to me saying, John, you can't do what you're doing. Like, that's completely wrong. Nobody will ever pay you money for that. I'm like, well, the only people who get a vote are the people that write checks, like at Equifax. They like it. But I'll give you an example. Like, we file answers before our clients are ever served with the lawsuit. And people are like, that's heresy. You can't do that. That's totally wrong. I'm like, no. See, I want to get to trial quicker. I don't want to sit around and wait. Plus, what the court gets confused, thinks my client's been served, but it really hasn't. Or maybe my client has been served and they forgot about it. And now there's a default. So we file the answer immediately. We're wanting to get to trial as quickly as possible. Now, that's not the majority position. Majority would say you want to stretch this thing out. You want to delay it. You want to ask for lots of discovery. I generally don't ask for any discovery. I'm like, can we go to trial tomorrow? Now, part of that is I think that we're better in the courtroom. Now, that may be, false pride or ego, but I think that's, where we're strongest at. And so we want to get into that courtroom as soon as possible. The other thing is sometimes I sue the debt collectors for suing us. They sue us on a bogus case. I want to sue them. Well, technically we have 1 year from when they filed the lawsuit. So I really don't want this thing to drag out because I got that deadline looming out there. So my approach is speed and getting to trial. You have to know sort of the lay of your land. How are the judges? I mean, it's sort of like if we're in a battle, you don't use the same strategy if you're fighting in the desert as if you're fighting in the snow-covered mountains. Okay, so I know what my terrain looks like in Alabama, in Tennessee, maybe totally different in another state. Let's see. Tim said, oh, this is in response to what's that Prodigy Surge. It's a system automatically picks out errors, so I use it as a guide while also using my real credit report, pointing out errors on my report. Yeah, so there are different software systems that Steve Palmieri has one. There's this Prodigy. And actually, I don't know if this is the Tim from Alabama, but there's a Tim from Alabama who I think has his own software system. I'm not sure if it's available to consumers, maybe just to credit repair places, but there are some systems. There's something, Credit Versio. I don't know much about it. I know the guy that runs that does some interviews with John Olsheimer's, who's the expert for the credit bureaus. And those are, typically very good videos. And he has some type of software. So there's different softwares out there that are in existence and that are being developed on that. See, Robert, thanks, Sean. Always learn something. Well, you're very welcome. Thanks for your comment. Let's see. Kenneth asked, how do I do that Prodigy. Ken says go to their website, set up free account. See, Juanita, with repos, if you have gap insurance, a gap can cover some of the balance. Gap covers loss. It covers repos. That considered a loss. It would just depend on what the gap insurance policy says. To my knowledge, that's not considered a loss. Okay. But I guess they could write one like that. So you want to read the terms of your gap policy. If you do have where gap comes into play and that is paid, then that should reduce the balance. We had a case against one of the car companies. Sort of convoluted. I'll simplify it. Car was total. Car company got the gap insurance. Maybe they botched something with that. But anyway, they had false stuff on our credit report, and client had done a couple disputes, and we sued them, and they were trying to say, well, we don't understand how gap insurance works. Well, you sold it and you said you would handle it, so you're stuck with it. All right, let's see. Tim says account was closed, and they reopened the account. Well, I would just say, is that accurate? I mean, that's always the test. Each piece of data on a credit report, is it accurate? Is it complete? So is it an open account or is it a closed account? And, you have to sort of make sure you're looking in the correct spot. Are we talking about an open-ended account or a closed-end account? Like open-ended would be like a credit card. Closed would be like a car loan. It's 6 years, $500 a month. But then sometimes we're talking about, is the account itself open or is it closed? So you just have to, kind of look carefully at what's under consideration there. All right. Sasha sent you emails this afternoon. Educational. Great job explaining legal concepts. Well, good. I sometimes joke with people, I have to make it simple for me. And that just has the nice benefit of being able to explain that to other people. But the funny thing is, even judges, they want it in a simple manner. When we tried jury trials, that's one thing I think it sets us apart from our opponents on the other side is we make this stuff easy to understand so that we sort of lay the dots out there and let the jury connect those dots. Whereas sort of the big tower law firm is in there sort of in a condescending way, like this is what you must believe. Well, people tend to not like being told what to believe, but when they form the conclusion on their own, then they tend to own that conclusion. Okay, guys, so that looks like all we've got, and I've got to run, actually get this lawsuit filed against the lovely credit bureaus and some other folks. So next week, if you guys just send me some emails, let me know if there's interest in, hey, I've been sued by Capital One. Or even if you haven't been sued, but you settle with an original creditor, maybe we'll make it a little broader. If I settle with an original creditor, how should my credit report show? And I'll point out to you some very common errors that we see with that. So you guys have a great one and a fantastic weekend, a wonderful 4th of July, and I'll see you next week. Okay, bye-bye.